Hello and welcome everybody to today's discussion on the UK's data reform plans. I'm Ben Muller and I'm a senior policy analyst at the Centre for Data Innovation. Last month, the UK government launched a public consultation on its plans to create an ambitious, pro-growth and innovation-friendly data protection regime that underpins the trustworthy use of data. As part of this consultation, the Department for Digital, Culture, Media and Sport is attending a number of panel discussions and roundtables in order to canvass public and expert opinion on data policy. We live in a knowledge economy. Information is its most valuable commodity, and data is the means with which we can make sense of information. It's fantastic that the government is taking this to heart and working to design data laws that will enable the UK to embrace the many opportunities that digital technology provides to make our societies healthier and wealthier. Today, we're going to discuss Article 22 of the GDPR, the right to opt out of automated decision-making. What improvements to this law could stimulate growth and innovation without harm to users? I'm really pleased to welcome our panelists to today's event. We have with us Omir Teen, the partner at Goodwin Procter law firm and former vice president at the International Association of Privacy Professionals. We are also joined by Jonathan Kursop, who's a partner at Pinsent Masons LLP and a data law expert. We have with us Andrew Orlovsky, technology commentator and columnist at the Daily Telegraph, and Christian Stout, Director of Innovation Policy at the International Centre for Law and Economics. Thank you all very much for participating today. And now for some opening remarks, I'm going to hand over to Isabelle Depot from the Department for Digital, Culture, Media and Sport.
Thank you very much, Ben, and thank you all for coming along. It's very much appreciated. Before I sort of delve into a little bit of the AI section and of the consultation, and more specifically Article 22, which has been said the conversation today is sort of centered around, I just wanted to also set the scene a bit more broadly for the consultation and sort of what we're aiming to do with the consultation more broadly, and also with the specific section on Article 22. So the consultation was a next step in delivering Mission 2 of the National Data Strategy, and has been said that's set out to deliver and secure a pro-growth and trusted data regime. It's not an exercise of ripping up and replacing the UK GDPR, and we are deliberately building on its foundations rather than making wholesale changes, but we do want to make improvements within the regime to take the grit out of the machine across key 5 themes and chapters. What's important to note is that we want to have a very open dialogue on proposals, of which this session today is also a testament. The consultation document, as you may have seen, is a mixture of white and green proposals. Some proposals are very concrete, while in other areas we ask more open questions, including Article 22, which I'll come on to. There's a 10-week consultation period already going on, and we are consulting until the 19th of November. And so we very much welcome the opportunity to talk to you today as well, and stand ready for follow-up conversations if you would like to. For the purpose of the event today, as we've already mentioned, we very much want to focus on sort of the AI section of the consultation document, and in particular the Article 22 section. We have 3 more themes in the AI section, as you may have seen. One is around fairness, one is around building trustworthy AI systems, and the last one is around public trust and sort of covering some of the challenges arising from profiling processes. But today is all about Article 22, and I just wanted to open the session by saying that we're very keen to gather evidence on how Article 22 works in practice. We're very aware that the current terminology in the article, so only applicable to solely automated processing, or and only kicking in when there's a similar legal or similarly significant effect produced on the individual, can cause confusion. And the result is that some high-risk processing may not be captured by the article, and that on the other hand, organizations may err on the side of caution so as not to automate processes at all. So the government really recognizes that there's a genuine need for the safeguards as containing Article 22, and that within the sort of broader data protection framework. but it really may not that be clear how and when they should be applying, hence causing confusion and overall uncertainty. So we're here today, and with the consultation obviously more broadly, to broach as broad debate as possible on this topic, and to ensure that the article is sufficiently future-proofed in the face of increased automation, and also to ensure that the necessary protections are in place and that organizations sort of know how to navigate those and when they should apply. So without further ado, I very much look forward to hearing from the panel and from the room today. And thanks very much once again to making the time on your Friday afternoon right before we dive into the weekend. Ben, I'll hand back over to you. Thank you.
Thank you very much, Isabel. And now we're going to move on to the moderated Q&A, followed by audience questions. Please submit any questions you have via the Slido panel under the video on the event page, or the Slido link in the YouTube description. And I'm going to try to get as many of you as I can. But let's kick things off. Christian, first question to you. Does the right not to be subject to automated decisions with legal effects deprive the UK of the ability to take advantage of beneficial and low-risk automation opportunities? For instance, I'm thinking of COVID pre-screening tools that can gauge whether a patient is at high risk of complications.
Great question. I think that Article 22, first off, any kind of legislative intervention like this is going to have costs and benefits. So it's always important to understand that there are definitely going to be costs no matter what you do. So when I highlight these costs, I'm not trying to say that GDPR is the worst thing ever, where Article 22 is the worst thing ever. Just these are the costs that I see. So I definitely see costs involved in how Article 22 is framed. For instance, I think there's still a good deal of ambiguity about how it exactly applies, whether it's construed as a general prohibition, whether it's seen as an individual right for people who are subject to automated decision making, which in turn leads to a great deal of legal ambiguity for firms that try to comply and for individuals that want to access services. So that right there is going to have pressure on the sort of innovative potential that firms operating in the EU are going to be able to deploy. I think that some of the costs that this leads to need to be taken seriously. For one, if you want to have an effective privacy regime, having something that's highly prescriptive like this, and we see this in the US and the EU, and I'm sure in other countries too, but those are the areas I focus on, you see a lot of compliance theater that emerges from firms. So you might want to tell people and firms that they need to have, a certain set of safeguards that guarantee certain rights are protected. But, for instance, like in an automated decision making, you could put a trivial contact point for a human in the loop who simply just signs off on things, and then the system runs the way the firms would have run if there hadn't been the regulatory intervention anyway. So you're essentially setting up like a prescriptive way for them simply to do like a pro forma compliance. So you're not even achieving your ends that you wanted to achieve there anyway, I think that some of the other bad effects are that you lose the value of something like contracts of adhesion, which are not usually seen very favorably by a lot of commentators who look at them. But if you look at the economic effect of contracts of adhesion, sometimes they're good and sometimes they're bad, just like anything else. So there are some instances in which take it or leave it contracts, might be unfair contextually to individuals. There's a lot of instances where they're not. So, for instance, the hypo that popped into my head, not necessarily the COVID one, was on a lot of the innovation that you see emerging in the US and the EU around fintech and providing frictionless automated loan grants to individuals at the point of sale. You starting to see it a lot on websites. I think it's very popular on like Shopify websites where you can do a buy now, pay later type of thing. It's like instantaneous credit, checks, and grants. Now, that sort of innovation becomes much more challenging to implement if you have to have rights of appeal, if you have to have humans who are doing like full review, if you have to have a right of explanation on those things, you're going to dry up access to those sorts of things. And the effects, maybe that's worth it in the trade-off for the EU lawmakers and policymakers. Personally, I tend to be a little more solicitous of trying to allow this experimentation and identify harms on the back end and then rectify them that way. But anyway, that's my view of the costs that we do see from this approach.
Yeah, that's a very interesting contribution, and I think it's a nice segue for my next question, which is to Jonathan. from a legal perspective, does it make sense to draw a legal distinction between decisions taken by a human and those taken by an algorithm? Do you think the key point is the means of making a decision, or the point is the outcome of the decision and the routes of redress available to a subject? And does the answer to that question suggest broadening or narrowing the scope of Article 22?
Quite a lot in that question, Ben. I guess you can see what drives this and the distinction between human and machine, if you like, and it's quite a subjective reasoning. The idea of individuals being uncomfortable with the thought of machines and automatic decisions being made about them. I do think, though, from a legal perspective, that distinction is a little bit artificial. In particular, you see this when the right to have an automated decision, or a decision based solely on automated means, challenged or subject to human intervention or human review. And what you sometimes see there is essentially a human applying the same rules that the computer did to come up with the same decision. There isn't a different decision if you apply, for example, if the decision relates to the decision whether to lend money to someone and is based on certain criteria, age, income brackets, etc. A very simple kind of example. Well, the decision won't be any different if that decision is made by a human using the same tools. So I think in that sense it is a bit artificial. I guess what I would say, though, is as AI and algorithms, and I think we'll come to this in more detail later, become more and more powerful, the challenges around bias and explainability, it's inherent in that, and the prospect of decisions being made without anyone really being able to quite understand how they get there. I think that is what this provision is kind of designed to be a check on, and to provide comfort to individuals that they have some control and they have the ability to speak, if you like, to a human to get them to challenge that. But how that is then applied legally is a real challenge going forward, I think.
Can I jump in here, Ben?
By all means.
So I fully agree with what Jonathan just said. I question whether the basis for the legal distinction should be whether, the decision maker or the algorithm really used is human or machine. Because, humans too, if you will, operate based on an algorithm and apply a certain type of logic. And, they're not inherently better or worse at decision making, and certainly at fairness, equity, considering all criteria than machine are. Maybe actually for the last bit, machine are better. I think the key distinctions should be outcome-based. Explainability. Can you explain why a certain decision was made? Intelligibility, like, is it clear, or is it just completely a black box? And some of the back-end processes, due process, review, appealability, you have an address you can challenge, maybe you can correct errors and mistakes. And if you kind of flip back, 40 or 50 years, you look at the Fair Credit Reporting Act in the United States, one of the reasons that FICO scores were introduced, so sort of the formal credit scores that we see today in the US, was to avoid the bias and discrimination of human decision-making, loan officers who would eyeball a candidate and say, you know, this person is black or white or Jewish or Irish or whatever the case may be, and then, you know, apply a human algorithm in an unjust way. So I think the point is that it seems to me that basing like this entire legal edifice on a distinction which isn't necessarily the right one and which comes across as a bit crude is not, you know, the 21st century way to go.
Could I also comment on that? So to Omer's point, I think it's absolutely correct that that distinction is probably the wrong one. What you want to think about, in addition to being a lawyer, I have a background as a software developer, so pardon me if I get a little geeky on this, but what you want to think about is this in terms of inputs and outputs on the software system. What you really care about when you're testing a software system is how the outputs come out, right? That's where you start your debugging, right? So if we have this system which is having, you know, say in the United States we call it disparate impact, and you want to examine that and you want to figure out whether that's the result of a problem with the algorithm, that's where you start your analysis. You don't want to start it at the beginning, in my opinion, where you're making this arbitrary distinction, as Omer rightfully pointed out, between human intervention or a machine intervention, because in fact, machines stand the benefit of being highly objective as long as you give them the correct set of inputs. The other thing I just want to say quickly, when you're thinking about explainability of algorithms, one of the points that I try to make sure everybody understands when I talk to them about it, and I think we know it when we hear it, but it's hard to remember, this is all probabilistic. The algorithms that are being used these days are not, they're not the kind of thing that you can just open up the source code, trace through it and say, oh, this is why it made this decision. What you get when you analyze these algorithms is the probability that a certain decision was made given a certain set of inputs, which means that regulators and policymakers have to understand that even if they're looking at a harm that you can identify and say, look, this algorithm did wrong by this person, it's still going to have to be put in the context of how the probabilities that that person would have been affected by this given algorithm, given all the different sets of inputs. And it might be the case that you're always going to have some amount of error on the outcomes that you're just going to have to live with if you're going to have automated systems. And that might be worth it in the long run.
Well, very interesting contributions. Andrew, you've been sort of following and observing and commenting on the debates around various issues to do with technology governance for a while now. I was wondering what your thoughts are on the way that this debate has evolved around data and privacy and the kinds of legal frameworks that we rely on, or that we are designing. And whether you have any comments on sort of the underlying philosophies behind attempts to regulate a very dynamic, fast-moving domain like digital technology, and how fit for purpose the sort of contemporary memes around the right ways to govern technology are, in your opinion. You're on mute, Andrew. Has to happen at least once in every podcast.
I think the word dynamic is really important here, because and it's absolutely key to understanding the situation generally and specifically with Article 22 and automated processing. I mean, I think there's a subtle. I've been very vocal and prominently critical of the GDPR, and I've kind of watched, even from within companies, where this enormous regulatory burden is placed on people. But I think the context is really one of where there's a techlash, if you like, against large technology companies. That's not just in the West. It's not related to any particular political wing. It's also China that's throwing tech leaders into prison. So there's a dynamic where trust, I think, needs to be brought up, and very basic fundamental things, once they're agreed on, you can then have greater trust. So I'll give you an example. I mean, to me, privacy is vitally important, and the respect of the individual is an Enlightenment tradition that technology companies have not really seemed to respect terribly much. But the backlash against this from the privacy parts of the privacy movement seem to be so extreme. They remind me of Extinction Rebellion in a way, in which they've kind of talked and thought their way into a cul-de-sac where any use of data is regarded as as a violation, as a very kind of profound violation. Now, I think we have to have a much more subtle debate about this. I think the UK's intervention specifically on 22 largely takes the problem away from technology companies and puts it on the individual in a way that isn't terribly helpful. So we go from ex ante to ex post, to put it crudely, and I think that's just seems to be sending a strange signal to the public at this particular time when we're looking for more accountability. And from my point of view, I'm a market guy. We need more markets for technology and technology products, not fewer markets and necessarily the minimum regulation, really. But the UK's intervention does seem strange at this time.
That's an interesting comment on this sort of the current zeitgeist.
Could I just wind back, Benjamin, a moment? I mean, I think it's premature to have. I mean, I kind of regret Article 22 is there at all, and it's a mess. It's a really gnarly subject, and that's evident from Isabel's subtle discussion of this. It kind of punts the issue itself. I mean, it's unusual in drawing a bright line. Most EU regulations don't do that, but I feel it punts so much into recitals and into the courts that a common law approach might make more sense at this stage, because I think context is so important here. There's areas where people don't really mind their personal data being processed. In fact, they're kind of, I think, in some of the health issues, they're more upset it isn't being processed. And there's areas where it's vitally important, and unless we sort of have a greater granularity of data, which I think will develop over the years, it's too early to be drawing conclusions like post is good and anti is bad, or vice versa.
Or just on that point, Andrew, as well. I mean, I think this is the GDPR is a funny patchwork of kind of principle-based legislation where there is quite a degree of flexibility and ability to apply context, and the provisions like this, which are very prescriptive. And in the DCMS proposals, I have some sympathy with the concept that actually, if you're satisfying a lawful basis for processing the data, get a more principles-based approach with emphasis on the context, then surely that's sufficient. Why do we need something over and above that? So it's I think this is one. I wouldn't say the whole of the GDPR is kind of takes this approach, and I think there's sufficient flexibility as a framework for technology to thrive. But this is a good example of a provision which seeks to be overly prescriptive and gives it a bad press, if you like.
Can I just add here? I think this is actually a good issue or article, if you will, of GDPR UK GDPR, to sort of put aside the data minimization or maximization discussion, which we've just heard a little about, like, is more data good or bad? Because in a way, it comes from a different angle and different set of rationales and logic, which I think are more due process oriented than privacy focused, and therefore I think can allow us to kind of lower the flames of sort of the policy storm that obstructs a lot of the discussions in the privacy and data protection space. Because what I mean is that Article 22, first of all, its provenance predates GDPR. It was already in the 95 directive. And I actually don't know exactly where it came from, but I suspect it came from one of, the European privacy data protection legislation instruments before the directive. So we're talking about like 1970s or 1980s logic and kind of perceptions about AI, essentially, which, even today, at least in policy circles, it's still pretty nascent and in a way premature, and not to mention the 70s and the 80s when it was, quite literally science fiction. So to take that and run forward with, I think would be a miss. And Andrew talked about dynamics. I'll give just one example with power dynamics concerning the human in the loop. So, the big focus of Article 22 is inserting a human in the loop and allowing individuals to benefit from that. But like I said earlier, it's very crude, because who is that human in the loop? Is it a judge? Is it a Court of Justice of the EU judge, someone with tremendous power? Or is it an engineer who is kind of working, the binary code, the bits and bytes in the process? Or is it a customer service representative? And depending on who that human is, I think it structures the power dynamics against the algorithm, the machine, in very different ways. So I'll give you a personal example. I was traveling, this is pre-COVID, I was still traveling, and I was actually in the UK. So I flew from the US to the UK for a couple of days, and I tried to get money out of an ATM, and it was blocked. Like, the credit card company blocked the transaction. So I called them, and, they have some algorithm there that flags this as suspicious activity, because usually I'm not in the UK, I'm in the US. And I tried to convince the representative, who was very human, that I'm, me, essentially. And the spoiler is that I really was me. I knew who I was, and she quizzed me about transactions that I did like the days before. And of course, it's very difficult to remember exactly, you kind of swipe your card many times every day. And finally, I failed her test, and she wouldn't release the hold. And, trying to kind of insert myself into her thought process. So she was sitting somewhere, maybe in Indonesia or the Philippines, and she gets like this call, and, she has the machine there telling her to block the card. Will she take upon herself the risk, the liability, of overruling the machine on that? So in that power dynamic, the human wasn't very helpful. Now, if I had access to some court, and I had a lawyer representing me, I think I would be able to prove that I'm me. But I think you get the point. It's not a precise enough tool, I think, from a policy perspective, to reach the outcome, which is accuracy, fairness, equity, and all those good things.
Yeah, that's very interesting, and gets at a lot of the thorny issues about how to design an appropriate legal framework that actually ends up protecting user interest. Because, of course, in the example that you gave, it's very easy to conceive of algorithm-enabled verification tools that could have quite quickly identified you as audio ID. systems which are already in use by the banks. I want to move the discussion on and raise this question to the panel as a whole by raising the question about what would be some viable alternatives to Article 22 or approaches to reform it. And there's a couple of ideas I have in mind. Is it, should we replace the blanket ban with a blanket permission and then go on to create prohibited profiling categories as opposed to permitted exceptions? Is that more permissive of innovation without undermining our rights? Or other safeguards to our rights not to be discriminated against that can be thought of that go beyond the limitations of Article 22, the ones that have already been discussed, such as the ambiguities. It's not even clear whether there's a general prohibition or whether it's an individual right. So I think there's fertile ground for us to discuss these alternatives. Jonathan, why don't we kick things off with you? But I'll ask the whole panel.
Yeah, I mean, I think the most obvious alternative is and one of the proposals is to remove it entirely on the basis that, largely, and alluded to it earlier, there are sufficient protections in the rest of the law. In particular, you still obviously need to satisfy a lawful grounds for processing. Likely that would be for most data legitimate interest grounds, which themselves have a right to object and challenge those legitimate interests. They have obviously a requirement to carry out legitimate interest assessments. So were the decision to be particularly onerous and have significant effects, whatever that means, then that is something that you'd have to balance against the interests that you're seeking to serve. So I think there's a good argument that actually the framework exists to cover this satisfactorily. I think if you start to try and, yes, you could improve this by defining what significant effects are, but I'd be reluctant to do that. I think part of the difficulty with this provision is its prescription, and actually when you start trying to be too prescriptive, that undermines one of the assets of GDPR, which is, like I said before, it's a framework largely or based on principles. So I guess that would probably be my option. I think the only thing I would say, and to kind of Omar's example earlier, there is still a public perception point. So if you were calling up and you were speaking to an automated voice who was telling you that you'd failed the test, I think you'd be even more pissed off than you probably were. So I think that's just the challenge, is doing it in a way that doesn't create in the public a perception that they can't trust this, and it's the computer says no, and they're trapped in this cycle, even if, as you very accurately say, humans are capable of making bad decisions too, and will often base those decisions on an automatically generated set of criteria. So I guess my vote would probably be just to scrap it and rely on the rest of the legislation.
Very interesting and nice connection there also to the points raised by Andrew about the sort of general public perception and the importance of that. Christian, with your legal background and previous analyses of those approaches to ensuring data privacy, what are your thoughts on appropriate steps to reform Article 22?
Well, to think about how to reform it or replace it, to what I was saying earlier, I think you need to consider what the costs are for the current regime versus the costs of alternative regimes. I think the current regime tends to be one in which, there's the phrase permissionless innovation for allowing innovators to sort of just go ahead and do things, and then we deal with the consequences later. I think the inverse of that is sort of at the spirit, at the core of Article 22 and the GDPR generally. So in a system where you want to impose a particular pattern of behavior on technology and the use of that technology, the costs that you're going to incur are a preference for the status quo, which means it'll be more difficult to compete. You're going to have less competition by paradigm. So, for instance, when the regulatory apparatus directs everybody's energy into thinking about how to comply in this way, you're going to have less interest in startups wanting to figure out different ways to do the things that are currently being done better ways, right? So, like one of the classic examples is Microsoft. Everyone thought was an unassailable monopoly in the 90s because of their grip on the application ecosystem, and then web browsers came and totally cut them out, and then mobile came and totally cut out the dominance that desktops and laptops have. Now, if we had regulatory paradigms that presume that desktop applications were the only way that people should engage with firms, that the data had to be strictly controlled, people who might have wanted to invest in doing sort of web-based startups or develop mobile ecosystems might have had second thoughts about wanting to invest resources that might have had difficulty complying with the dominant paradigm. So that cost, I think, is very important to keep in mind when thinking about Article 22. So that said, based on the history of technological innovation, seeing how these sort of paradigmatic competition challenges come from unforeseen quarters, my preference is to look for regulatory regimes and legal regimes that are a little bit more on the permissionless innovation side and look for harms. And to Omer's comments before, you want to be able to have sort of an empirical view of where the different harmed users are, who the people involved in it are, and actually be able to identify these things in an empirical way. And then if you take that approach, you can allow innovators in the EU to go out and try and experiment with different things that might not fit inside of the exact paradigm that the regulator's thinking of, and then fix those harms in the back end. So to that point, that long-winded way of introducing my idea, I think that you probably want to move away from the way Article 22 is thinking about how to regulate these concerns. You could probably retain something like Article 22, but with a duty to inform consumers so that they have informed consent. Because the fact is, even with like a contract of adhesion, if someone wants to interact with a firm and the firm says, look, this is the terms for using our service because this is the most economically efficient way to do it, we couldn't offer our service reasonably otherwise, that's still informed consent. The consumer has the option to opt out, and especially in areas, and you can put regulatory qualifications on this if the appetite in the EU is for more caution. So if there's sufficient competition in a market or it's a nascent market, you can allow consumers to interact with firms sort of on their own terms without having to have control of those contractual relationships. If there's relatively less competition, or if it's something seen as like a really core important function, something related to healthcare or something, perhaps you have more regulatory intervention on the Article 22 side. But I think that, looking for those exceptions is probably going to be more difficult than it's worth, and probably you want to go from the view of not having something like Article 22 or a very stripped down version of it.
Yeah, Andrew, what do you you're not by your own words, you're not a lawyer, but you do take a close interest in how these issues are treated by policymakers. So I guess in terms of general direction of travel, given your recognition of some of the costs and the cost to innovation and growth that GDPR creates, how do you conceive of the right ways to think of reforming this?
Yeah, I don't. My concern here is really with research rather than the costs to business. And in fact, I wish more attention had been paid to the administrative overhead costs that GDPR has imposed. It's a golden era for lawyers at the moment in the last 3 years. I think there's in fact, I'll agree with Christian on a lot of issues, but the idea that innovation is going to seize up unless we do something. Let me wind back a bit. I would rather not have an Article 22 at all, but it's there. And the kind of repeal that's proposed kind of reflects a kind of sense of entitlement that doesn't signal well. I mean, ask yourselves, is a class action more likely or less likely if the government's preferred repeal of Article 22 goes ahead? I think it makes it much more likely. I think it creates a reaction amongst privacy people that this has been a terrible destruction of human rights. And I don't think class actions are a terribly great way to conduct the legal framework. I would but I'd much rather see this creep forward through common law and examples where we build up a recognition that uses are different, research is different to advertising, for example, that different buckets of data have different qualities attached to them, that medical data can be anonymized, some other data can't be anonymized. In other words, this is quite a subtle issue. But Article 22 is there, and I think it does kind of reflect a sense of, it just seems a little tone deaf to me to repeal it and then hope that nothing happens. So research is my main concern here, and I think that's where the greatest scope for, if you like, liberalizing the law comes from. I'm not convinced by innovation arguments, really, because there hasn't been a great deal. And also, this isn't generally widely known, but in the cutting edge of AI, it's more about how you design the network rather than the data that you have. That era is kind of gone now. So I hope that kind of muddies the waters further, perhaps. But so, I wish Article 22 wasn't there, but this kind of simply brushing it away isn't. It's just going to react. It's going to create reactions which are and consequences which are not helpful to anyone, really.
Omir.
Yeah, I personally don't think the UK government should be afraid of reactions, and specifically in the European context, I think other European member states would have innovated around this had they been at liberty to do so. So, Brexit is a done deal already, and at this point, I think...
Sorry, Emma, there was a class action suit launched yesterday against Google and DeepMind for the use of health data. That was filed in London. I'm not worried about consequences from Europe, but there are many. We've created an army of privacy activists and academics now. It's an industry, and this is a cost to business. And they'll an inconsiderate repeal will have them down in droves, I think.
Got it. Just to reflect on what Jonathan said, kind of deleting Article 22 and resting on the rest of the legislation, specifically GDPR, I think, again, going back to my previous point of this not being a privacy or data protection issue, but rather something from another field, really, it's AI regulation. I think the rest of the laws which you would lean on here aren't just GDPR, or even mainly GDPR. It's laws around fairness and equity and discrimination and due process. And I think in that context, the important principles to kind of ground the new provision or law in are principles of explainability and accuracy and due process and an ability to challenge decisions. But I just want to say that it's not a simple fix. And I'll give another example. If you think about algorithms, machines that read MRIs, which we now see in the healthcare space, what would you rather be subject to? A human who has read, it depends what their experience is. Are they like in training, or have they been radiologists for like 20 or 30 years? But even in the best of cases, they've read maybe thousands of MRI images, compared to a machine that has seen and analyzed all MRI images in the history of mankind and has that kind of vantage point and perspective. I think a lot of people would prefer the machine reading, but then if you try to require explainability, I think, with real AI, machine learning and all that, the machine might be at odds, and it might be difficult to explain why it's made a certain decision. You kind of go into neural science here and try to get into really brain processes. which might be difficult to untangle, especially at a scale of, every chess move in the history of chess, or every MRI image in the history of MRI, which is really what we're talking about when we think about machine learning and AI. So I think the UK should charge forward and be, innovative and bold, frankly, about AI regulation. But it's not as simple, I don't know the answers. So I know what the problems are.
Well, that's one of the reasons why we're all gathered here today, to think about these issues more. And it's certainly striking to me that one of the themes that we are all in one way or another converging to is this notion that it's the ability to challenge decisions by a system that's really important, to ensure that the subjects of the decisions don't feel like they're powerless or voiceless. And in the context of GDPR, that seems to raise the question whether human review amounts to a concrete and meaningful concept, or whether the ability to challenge decisions can also be safeguarded in other ways.
Ben, can I just jump in here?
Go
it's
ahead.
not just to challenge, to explain, to understand, to correct, to amend, and to challenge. And then, when you think about human review, sometimes for a machine, it could be laughable. It's like a 3-year-old child trying to, correct a chess move by Kasparov, right? The machine is just so much more sophisticated. How could the human even start to understand, this machine, which has processed and seen in an instant every chess move possible, out of the trillion to the trillionth power. So it's difficult stuff.
Well, and what, to Omer's point, what the kind of explanation that you're going to get out of a system like that is actually going to need another machine to help the operator understand the outputs, because what you're going to have to do is some sort of second order statistical analysis of the outputs that come out of the first machine. And then you get that analysis and you're like, well, within these confidence intervals or whatever measures you're using, this is most likely why it came out this way, or this is most likely to be the result given the given inputs. If you really want to have the power of the ability to look at the history of every MRI in the history of man, which I think a lot of people understand the value of being able to do that, we're going to have to get very comfortable living with uncertainty and with the probabilistic nature of these things. And we're going to have to adapt our regulatory frameworks or legal frameworks in a way where we don't think about it in terms of direct rights of appeal or something in the way we would if there was human decision makers that are suffering from certain kinds of biases. We need to think about different ways of approaching these problems.
Yeah, Jonathan, what are your thoughts on the concept of human review, especially as the scale and scope of automation is going to increase, and what might such a review look like in the future, particularly as we move into an era where algorithms get more and more powerful, and it becomes harder and harder to understand them or question the validity of certain outputs.
Yeah, I mean, I think to echo Omer and Christian just there, I mean, the role of the human, if you like, or to challenge decisions is, it seems hard to see how that's tenable, and you can see that this is something that was created in a different world. And I think Omer's point as well is, I think what people are most concerned about is the decision, right? So it's challenge the decision. So the context of that will be really important, and surely that will be governed by, or could be governed by, consumer law, by banking law, whatever the context of that decision, called procedural laws, whatever. So it's almost a bit of a strange beast, Article 22, and this right of human intervention. because it's specifically where personal data is used to make a decision about you. But what are you challenging? They're challenging the use of that personal data to make the decision. Well, that would make the most sense, but really you're challenging. You'd be most concerned. You want the decision revisited, and actually, there's no way that's going to come to a different decision, even if you can work out how that decision was made. To the point I made earlier, the inputs will be the same, and as everyone else is saying, the computer will probably have made a better decision based on a lot more analyses. So the kind of relevance of that seems to be diminishing. I just come back to, it is more an emotional crutch, if you like, for individuals to think there is a person involved that they can speak to and say, I don't like this. But I think the actual ability to change the outcome is sort of remote and diminishing.
Yeah, I wouldn't. Hi, am I live?
Yep.
Yeah.
Yeah, no, I think there's cases where a lot of the time that's correct, but a lot of the time the customer relationship entirely depends on the hope that a manager will overturn a decision. From what you've just said, there's no way you're actually taking humans out of human decision making. From what I said, I mean, you've said the human will never override a decision.
Well,
I think a lot of us depend on the fact that there should be somewhere. We can never find them, but that's a different issue. That when there's been a really egregious decision, I'm a millionaire and I can't get a loan for £1,000, that you will be able to refer it to somebody. That's so essential for trust in these systems. I think we diminish that subjective view of things at our peril, really.
Well,
I don't disagree with that. I suppose what I'm saying is, if the assumption is that an automated decision is, and the power of the data and the tools that can be used now will be delivering more and more accurate for however you're whatever criteria you're basing on decisions, then I guess my point is, yes, from a customer relationship perspective or from a human interaction perspective, the role of someone to speak to convey that decision, to complain about it if you're not happy with it. But if the inputs are all accurate and the algorithm is measuring the right things, then how can it be that when the manager does review it, that they will come out with a different decision? And I suppose that's what, there's surely a
because they've got something that the machine hasn't got, which is common sense.
Right.
We're assuming these are godlike machines that have everything programmed into them, and they can be very good if they have a lot of context programmed into them, but they don't. And it's funny, Omar's anecdote was great, because I lived in San Francisco for several years, and each time I touched down from the UK, my card would be cancelled as well, and I used to have to go through this rigmarole of ringing the UK back again, very tired after a fly, and just say, hello, can you unblock my card, please? But you're assuming that these machines are perfect and that no manager would be able to undo that decision. I think it's so important to the trust in these systems that they can and they do. They lack context, for example.
I think Andrew and Jonathan both are having the same good point. It's dependent on how good the algorithms are and how good the input data is. And I think that actually points to where you want to focus your policy attention. You don't want to focus it necessarily on the systems as they're running and how they're having actual results, except insofar as evidence of the efficacy of the algorithm. What you want to think about is maybe what are the standards that go into the creation of these algorithms? What is it that needs to be considered? Look at the patterns of impact and create like a best practices for people who create these algorithms to make sure that developers have the tools they need to actually make good algorithms. Because the truth is, if we assume we have a good algorithm or a decent algorithm, better than humans, right? Humans are notoriously biased in a variety of ways. If we assume we have an algorithm that performs on average better than humans, what people who want to put a human in the loop in that system are actually doing is asking for the introduction of uncertainty and bias back into a system that on average is performing better than flawed humans are able to do. And I say this as a very flawed human who makes a lot of really bad decisions. I really appreciate it when machines help me. So this goes to the earlier point I was making, that what we need to think about is where our point of interaction with our policy is in the technology space. I think putting it at the level of humans being able to appeal particular decisions probably generates more costs than benefits, and we need to look elsewhere.
Just again to Jonathan's point, I definitely take the point, Jonathan, of humans benefiting from the emotional comfort of talking to an actual human or just knowing that they're involved. And, you know, when you regulate something like this, maybe it does need to weigh in somehow. But I mean, I'm just not sure what the result should be. I think, you know, an example from a completely different context, if you think of the military environment, people might feel uneasy about being killed by a machine, by, for example, a drone, and prefer to have a human operator there. But, you know, human operators also make a lot of mistakes, and there's tremendous collateral damage with human kind of orchestrated military operations. And on the other hand, you know, the drone could be incredibly precise. And again, it has a very clear picture. It sees everything. It has thermal imaging and movement and all that. It can identify ages of people. But we still might have this visceral reaction of it's not right, you know, to be terminated by a drone without human involvement. So I think it's a complicated, you know, type of dilemma, and it certainly involves feelings.
Right, a less military example to Omer's, but which is becoming increasingly common today, is the use of automated driving systems, right? There's a lot of people who study this, and there's different levels of automation, and there's a lot of evidence that suggests that if we could just get to the fully automated version of driving, accidents would go down like crazy. There'd be so much human life saved. But we have imperfect driving systems, and we also have a preference for being able to allow humans to interrupt the automated driving process, which evidence is starting to show actually can cause some really horrific accidents if it's not done correctly. So the humans in that system actually introduce more error, and I think in a lot of systems humans introduce more error, and we have to be very careful about arbitrarily involving them.
So it's a fascinating discussion, and we could keep it going on for hours, but let's give each and every one of you an opportunity for a brief closing statement, no more than 30 seconds, please. And we're going to go clockwise. Christian, what are your final thoughts?
Final thoughts on regulating Article 22 and privacy generally, things like that. I think what you want to try to be is solicitous to people who might be in firms that might be innovating new technologies. I think it was Andrew who said we haven't had innovation in a while. I would disagree. I think there are areas that is occurring, and that we want to make sure that even where it is perhaps slower than we desire, we leave room for people to come in and do these things. That's not to say we don't want regulatory protections. We just need to think about regulation differently now, given the high degree of automation that we both have and we want in the future. And we need to adapt our frameworks that way rather than thinking about them in a 19th and 20th century model.
Thank you, Christian. Jonathan, what are the final thoughts you want to leave the audience with?
I think my thoughts would be, you know, the GDPR, or the UK GDPR as a whole, is not entirely broke at all, and it's a good framework, and there's plenty in it to provide the sorts of protections that Article 22 is driving at, as there is in other law and regulation. So I guess we shouldn't be afraid to get rid of a prescriptive provision like Article 22, but on the basis that actually there is sufficient protection elsewhere in if we communicate that and it is communicated to individuals so that they have comfort and awareness that that's the case, I would see as the way forward.
Omir?
Yeah, I'd just like to applaud the impressive process that DCMS has put in place here. The UK obviously is kind of at the cutting edge of policy thinking on these issues, so I'm grateful to be part of it. Thanks.
And lastly, Andrew, what are your final thoughts?
I'll finish where I came in, really, which was let me wind back. There's a phrase called long history, which is very popular now in civilization scale events, and try and put them in that kind of context. And I've always tried to argue the internet should be seen in the terms of a very long process, and we're just starting out on this. But I think one factor, there has to be greater trust in systems and the companies. In the late 90s, technology companies were given this fantastic carve-out by the government, which essentially made them not liable to be sued in many areas. And I think they've got a taste for that, and they'd really like not to be sued maybe in cases where they should be. So I think the regulatory backlash there's a background of there may be a backlash of litigation if we kind of return to making tech companies free from the liabilities that other people have. But yeah, I think we can do a lot more with different frameworks and do a lot more thinking seriously about data.
Fantastic. Well, thank you so much for participating and your highly informed thoughts. Thank you, Isabel, for your opening remarks, and to DCMS for co-convening this panel. And thank you all today for attending. I hope you had lots of food for thought out of this session. Take care, everyone. Have a great weekend. Thanks again.
Thank you. Bye-bye.